Welcome back to the world of Deeptech. A few months ago, we looked at what investors look for in intellectual property. We also looked at several types of partnership agreements, including collaboration, options, and licensing agreements in our earlier videos. Here, we will take a step back and look at the broader IP strategies that Deeptech startups need to adopt to protect their intellectual property and competitive positioning optimally. Deeptech startups protect their intellectual property primarily using patents, trade secrets or know-how, copyrights, and trademarks. In this video, we will discuss only the first two. Why do we even need to worry about a strategy for intellectual property protection? First off, protecting intellectual property in the form of patent is a ladder with escalating expenditure as we move through the different stages of the process. It can also take significant time of key inventors to get it right. If done right though, a good IP strategy can return several times these investments in revenue and time by defending the company from potential lawsuits and competitive pressures. It can create effective barriers of entry for competitors and provide the startup with a significant competitive advantage. It also allows the company to have freedom to operate, work around barriers erected in their way by their competitors, and build leverage in negotiations with partners and investors. It can also provide them alternative paths to commercialization in face of changing competitive landscape. A startup with a strong IP portfolio also has a reputational advantage that can help them with their fundraising efforts and their credibility with customers. It can also help them attract the best talent available. Before we go further, let's do a quick recap of what patents are all about. Patents are the rights provided by the government to the applicants for a limited time to exclude others from using the invention in exchange for full disclosure. The typical duration of patent protection is 20 years from filing of the non-provisional or PCT application. Since it's a right given by the government, it's a territorial right, but the information disclosed in the application prevents everyone, including the applicant, from getting a patent on the same invention in any territories at a later date. Since it is only a right to exclude others, it doesn't automatically give the owner the right to make the products based on the patent. In order to do this, the owner of the patent needs to have freedom to operate. Since the information is now in public domain, others are free to use that information to build their competitive strategies and workarounds. An application for a patent is evaluated based on novelty, inventiveness, and utility. A patent office determines these aspects based on the information provided by the applicant and prior public information that they can find. So, there is always a likelihood that the patent office was unaware of some prior art when it made the decision to grant the patent. This opens the door for lawsuits to invalidate the patent. A typical timeline for a patent may start with a provisional application, and it can take anywhere between 3 to 5 years to get the patent granted. Majority of the expenses for patent filing comes 30 months or 2.5 years after the priority date. This is when the startup has to decide on the countries where it should file national applications. In deciding whether to patent, startups have to take several elements into consideration. The first one is public disclosure. Is the startup planning on a roadshow, demonstrate the product to third parties, install the product at a customer site, provide samples for evaluation, or enter into collaboration agreements? If any of these is likely to happen in the near future, then relevant patent applications have to be filed prior to those events. The second consideration is whether the technology is easy to reinvent. If it is easy to reinvent, then the patent application has to be filed as soon as possible. Next, if the technology is discoverable based on the various attributes of the product, then a patent should be filed. The cost of a patent that is not enforceable is something very few companies can afford. So, the legal infrastructure to enforce a patent should be evaluated before deciding to file a patent application in that territory. If the legal infrastructure does exist, the next consideration is to see if it is easy to demonstrate infringement. For example, let's say you developed a new method to synthesize a chemical and patented it, and you suspect a competitor to have infringed on your patent. How can you demonstrate that the competitor is actually using that method? It's unlikely that you can gain access to the competitor's facilities unless you can demonstrate possible cause. Unless the new synthesis method gives the chemical unique characteristics that demonstrate infringement easily, it's very difficult to prove this. So, the synthesis method patent can be hard to enforce. You might still file it for other strategic reasons we'll discuss momentarily, but from an enforcement perspective, it doesn't make sense. The startup then needs to evaluate if the cost of filing, prosecuting, and maintaining the patent and the resulting public disclosure of the invention is worth the benefits in deciding whether to patent an invention or keep it a trade secret. It should also evaluate how the cost of infringement by competitors compares with the cost of pursuing patent protection and enforcing it. In general, the more breakthrough the invention, the less urgency there is to file the patent application, as it is hard to reinvent and the cost of public disclosure may be higher than the benefits. Another consideration in whether to patent an invention or keep it a trade secret is the level and sophistication of information controls in place at the company. If information related to key inventions is well guarded and access to it is well controlled and traceable, then the invention can be guarded as a trade secret for long periods of time. Once you decide that patenting is the right strategy, the next question is when and where to patent the invention. Very broadly, these decisions need to be in sync with the broad business strategy and markets of the company. Based on the company's 3 to 5 year targets, the team has to evaluate the competitive landscape and establish a strategy to fill the IP gaps. Keeping in mind the typical timelines for patenting that we discussed earlier, the team has to align major developments there with major developments in business like pilot testing and market entry. Since patenting involves significant costs, these developments have to be timed to be in sync with major fundraising rounds. It should also be synced with the timelines for entering into major partnerships related to technology development and market entry. In a technology space which is very crowded, an ungranted patent application leads to a lot of uncertainty that may impact valuations and partnership agreements. In these cases, the company could opt for accelerated prosecution so that they have clarity on claim scope and allowances as soon as possible. The first set of IP strategies that a startup can adopt are offensive strategies. These are based on regular competitive assessment of the IP landscape to identify competitive technologies and filing blocking patents to cover them. The second set of strategies are defensive in nature, where the team is on the lookout for ways to maintain their freedom to operate and to sustain their competitive advantage. Related to this is defensive publication strategy, where the team makes public disclosures and files patents to prevent their competition from filing blocking patents in their space. The case of filing a patent application for a synthesis method that's unenforceable that we saw earlier is an example of such a strategy. The team should perform their own FTO studies and be prepared to disclose their strategies to reduce the uncertainty around FTO to the investors. One of the best strategies a deep tech startup can adopt to protect their technology is to ensure that they file quality patent applications. They can ensure this if they hire a good patent agent and if inventors are involved deeply in the drafting and prosecution of the patent application. The inventor should ensure that sufficient backup positions are included in the specifications to modify the claims during prosecution phase. They should ensure its technical accuracy and take care of all potential workarounds in the claim scope. The application should have sufficient detail with supporting data and examples that cover the range of values used in the claim scope. Another strategy that the team can adopt to strengthen their position is to do a review of the patent landscape and identify white spaces in the technology and file broad patents to stake their claim there, even if the company is not actively developing technologies in that space immediately. While these are broad general strategies, the specific strategy adopted by a company depends on its domain and stage of growth. In general, companies in materials and biotech space focus on filing a few high-quality patents, while in ICT-related domains, the number of patents plays a significant role in its reputational value. Young companies whose main assets are related to IP tend to have a stronger emphasis on IP filings compared to larger companies that have stronger information control systems that can help them maintain their know-how as trade secrets for longer. In summary, these are the different considerations that a company needs to evaluate to craft an IP strategy that suits their budget and stage of growth. Thank you for watching. Before you go, don't forget to like this video and subscribe to this channel. Thank you.